crime and contract of fraud. When we've got fraud, it will basically bring about rescission of the contract. It's a tort, and it can be sued upon as a crime as well. Contracts can be discharged in a number of ways. We studied in the book bankruptcy, impossibility, expiration of the statute of limitations, frustration of purpose, and so on. Any of those, all of the above. If you receive a credit card offer in the mail that's unsolicited, and in this card it says you'll be charged an annual service fee of $50 whether or not you use the card. If you don't ever use the card, you are not responsible for payment of that fee. Your silence cannot be used as acceptance of that card. Termination of an offer and termination of a contract sometimes can occur. We studied ways to terminate a contract or terminate an offer, and then I pointed out some of these are also ways to terminate a contract, including destruction of the subject matter. The mailbox rule also has another name called the deposited acceptance rule. All right, chapter 12, torts and cyber torts, maybe a little bit of 13. I don't think there are any strict liability questions in here, but we'll look. 9 questions. Another one of those questions about a guy wakes up in the middle of the night and there's an intruder kind of question. He shoots him, is he guilty or not? That's one of those types of questions. You've seen those before. Not the same question as you've seen on your exam book. The use by one person of another person's name, likeness, voice, or other identifying characteristic is the tort of appropriation. Remember on that test, a lot of you put misappropriation. That's not correct. By the way, I looked up the case on Bette Midler. It was not the song I thought it was a different song. I forgot now what it was. To completely prove negligence and recover damages, what did we have to prove? This is the outline of negligence. We had to prove a duty of care, breach of the duty, injury, loss, or damages, and both actual causation and proximate causation. In the Palsgraf case, we learned that Helen Palsgraf was not going to be paid for her injuries, at least not by the Long Island Railroad. That Long Island Railroad was not liable to her because the causation was not proximate. Again, they were supposedly protecting this guy getting on the train, and again, it was unforeseeable that they knew he had any kind of firework. There was a famous case involving intentional interference with a contractual relationship in your textbook. You'll remember that's the one involving Lumley and Guy, two people who ran opera houses in London, England back in the 1800s, and an opera singer by the name of Joanna Wagner. This next question is kind of one of those questions where it's like a combination of true-false questions. You know, which of the following is true, which of the following is false? So I'll just read each one to you and see what you answer. Every tort is also a crime. Every tort. All torts are also crimes. Yes or no? True or false? All right, he's shaking his head false. See, you're correct. There are plenty that are similar to crimes, and there's some that have different elements, like trespass could be different for criminal trespass versus civil. But there's some that don't have crimes associated with them all, like defamation. All right, every tort plaintiff is represented by an attorney for the government. No. And the reason is that torts are considered private actions, private disputes, and you don't have a government attorney. You have to hire your own attorney. All right, next one. Every tort lawsuit is a civil matter, meaning not a criminal matter. He goes, I'm not sure. And the answer is yes, that's correct. It is a civil matter. Last one, every tort is punishable by a fine and/or imprisonment. The answer is no. That's criminal law. Fines or imprisonment are used for criminal law, not for civil law. All right, when we studied defamation, we found out that a person who has who claims they've been defamed, meaning that a false statement is made about them and it's damaged their reputation and it's been published. But if it's a famous person, then they have an additional burden. They're the plaintiff, they're suing, they're trying to say the damages, whatever they've been for defamation are, They also have to prove actual malice. Not only that the paper published something which was false about them, but they knew it was false and they published it anyway. When we talked about assault and battery, we learned that assault and battery are not the same thing, and that assaults in torts, anyway, is sometimes confused with the criminal assault, but assaults and torts are generally do not involve an actual touching, but they can involve putting a fear or apprehension of immediate harmful or offensive contact is considered an assault. In other words, if I point a gun at you, that's the assault. If I pull the trigger and hit you, that's a battery. Contributory negligence as a defense in tort cases based on negligence is an absolute and complete defense. And again, remember, there are only like 4 states in the United States that still follow contributory negligence, North Carolina being one of them. Next chapters, 16, 17, 18 all together. 13 questions. A sole proprietorship, limited personal liability on a sole proprietor. But that sole proprietor can still have employees. They still own and control the company all on their own. A limited liability company is owned by what are its owners called? Those are members. Double taxation is associated for which type of corporation or which type of business entity? C corporations. In a general partnership where all partners are natural persons, they all have unlimited personal liability. In North Carolina, it's possible for a number of different business entities to have one owner. For instance, a sole proprietorship automatically has one, but you can have a corporation with one owner, and you can have an LLC with one owner. In North Carolina, the document you file in a county where a business does business under a name other than its own name, that is called a certificate of assumed name, sometimes referred to as an assumed name certificate. One of the steps in creating a North Carolina corporation is the filing of articles of incorporation with the Secretary of State. Corporations usually have perpetual life or duration. Corporation that's incorporated in one state doing business in a second state is referred to in the second state as a foreign corporation. Maximum number of shareholders an S corporation can have, by the way, I had somebody call me the other day who wants to form an S corporation, is 100. Used to be 75 though, and before that it was 35. So guess what the wrong answers are going to be? 75, 35, I don't know. I might throw a 50 in there and maybe another. Who signs the articles of organization filed with the Secretary of State? That would be the organizer or a member. Now, I often do this for people that I'm forming an LLC for. I'll file it as an organizer, but I'm not a member. But now it's allowed to have a member file that. Okay? In a small, closely held company, all kinds of companies, general partnerships, LLCs, limited partnerships, S corporations, we have a type of agreement that we'll often put in their internal documents which restricts the transfer of interest in the company and gives the surviving owners the right to buy that interest. Let's say if somebody dies or something. That's called a buy-sell agreement, and we put it in whatever kind of internal document that company has. You can put it in the articles, but you don't have to. Nonprofit corporations, some of them are tax exempt, some of them are charities, some are domestic, some are foreign, but you generally cannot say that all nonprofits are any one of those things, because a nonprofit may not be tax exempt. In order to be tax exempt, you have to first be nonprofit. Chapter 19, 5 questions, and that's the end of the chapter, or the end of the exam. Chapter 19, agency, 5 questions. An agent for an undisclosed principal is personally liable for, well, we know that an agent for undisclosed principal is personally liable for contracts because the third party doesn't know who they're dealing with. The principal is undisclosed, so they have to sue the agent, and the agent therefore is liable. But don't forget, an agent's always liable for torts committed in the scope of the agency. The doctrine of respondeat superior is defined as a principal employer is vicariously liable for torts committed by an agent employee within the scope of employment. Well, are employers liable then if they hire an independent contractor? Assuming that they can't control that independent contractor, the answer is employers are not liable for torts committed by independent contractors. Among the various duties owed by an agent to his or her principal, remember what those are. And I'm going to give you a list of them, and you have to decide which one of them is wrong. Remember, it's LOADS, L-O-A-D-S, loyalty, obedience, accounting, disclosure, and skill, care, and diligence. That's slightly different from what you have in the book. The duty of loyalty that a real estate broker owes to the principal includes the duty not to secretly profit, to return any secret profit, and to disclose to all parties to the transaction that the broker is a partner, shareholder, or relative of any of the other parties to the contract. Ta-da! That is all. Again, if you post this or whatever, try to share it with people from the 9 o'clock class. You know, you can email people from your own section, but you can't necessarily email the other section. So if you're putting together study groups or something like that, maybe let somebody in another section know, let them put on their study